can only say these are incredibly shocking. They go so deep. Basically, they're saying that there was perhaps this conspiracy between the state doctor, the LDS Church, and the prosecution in this case. At the very least, this deserves some sort of hearing in court, don't you think?
Well, it depends because, listen, Lori is still incompetent. I don't think she can meaningfully participate in such a proceeding. I got to tell you, Michael, I have many clients who are in the state hospital here in California due to mental incompetency. I get calls all the time from the clinicians who work in the hospital and say, you know, your client had some legal questions and I didn't want to answer those questions. I urged them to call you. If I give you a number, can you please call your client? You know, that's how you handle it. You don't refer them to another attorney. You don't get into cahoots with the Church of Latter-day Saints to provide them with substitute counsel. It interferes with the attorney-client relationship that's already established. Now, if the client on his or her own decides that they're unhappy with their counsel, they can shop around even though they're already represented. They can call private attorneys and talk. That does not violate any ethical canon so long as the client initiates the communication. Where lawyers get into trouble is where they, of their own volition, start interfering with an existing attorney-client relationship without counsel's consent or knowledge. But I think this is a bit of a tempest in a teapot. It may be overblown. It's not to say it's not interfering with an existing attorney-client relationship, but the good news is I believe under state and federal case law, anything that she may have said while incompetent is inadmissible in court anyway, because it's all part of a competency proceeding that is judicially immune from admissibility in the trial proceedings.
You make fantastic points, a couple of fantastic points. The first one being that the circumstances surrounding this doctor recommending an LDS attorney could have been she had some questions, maybe in their conversation she was asking some legal questions, but it still raises my red flag when someone who works for the state has to know better. These are folks who are trained not only in how to treat people with mental issues, but also some of the legal issues involved and what they can and cannot do ethically. And this just seems like an incredible ethical violation that he would even mention to her that you should perhaps, he said these things, you should get rid of your defender now and go get someone at the LDS Church. And here's why it raises the eyebrows of folks looking at it, Philip, because Wood, who we know has inundated himself in this case in many ways, happens to be associated with the LDS Church. He's some kind of elder or something. He gave that in court at some point. So when you start looking at that, it raises a lot of red flags.
Yeah, it does. I mean, first and foremost, the practitioners have to stay in their lane. They should not at all interfere with the legal proceedings. I mean, to the extent that they need to prepare a progress report for the court regarding the defendant's mental competency, that's one thing. To talk about whether or not they can rationally assist in their defense, whether or not they yet understand the charges and the nature of the proceedings, but start getting into legal discussions, into the facts of the case, the quality of their representation, switching counsel. I got to tell you, that does cross a line, but I'm not so sure that it's enough really to remove counsel or to move her to a different treatment facility. I think a firm admonition from the court should resolve this. But I do think that part of the problem as well is that a lot of these mental health practitioners and frankly the medical practitioners at the government level, they only understand their clinical roles. They're kind of out of touch or not at all trained on the legal ethics involved. And some of them just might need training, frankly. They just need to be brought in, trained, and told what they can and cannot do with patients who are currently represented by counsel and embroiled in competency proceedings, and that should hopefully resolve it.
Oh, well, that's a problem. If they don't know what their ethical obligations are and not to do what he did, that's a serious problem, Philip. You know, the other thing that I wanted to get to, you mentioned that if in fact she is deemed incompetent, as we know she is at the moment, anything she said to this other attorney that she spoke with wouldn't be admissible in court. But my point was, what she told her attorney is the basis for these allegations, the basis for the motion in front of the court. How should the court look at those allegations? They're coming from her.
Well, you know, listen, at the end of the day, the court can hold a hearing. But let me ask you, though, what is the relief that they're seeking? What do they want? In other words, if the goal is to get her moved to a treatment facility, okay, so be it. Maybe everybody can stipulate that she needs to go to a different hospital.
Philip, they want this
If
whole
the goal,
prosecution removed from the case. They've wanted it for a long time. They felt that Rob Wood has inundated himself in this case to the point where he's made himself a witness. In this particular instance, he spoke to the attorney that she spoke with, got information from him, and they want him kicked off the case.
well, if they're seeking to recuse the district attorney, they have to show that the DA's office is embroiled in an irreconcilable conflict of interest. And I'm not sure that it rises to that level. I think the worst case scenario is you put a different prosecutor on the case from the same office, but to move it to a different prosecutorial agency, I think is extreme and maybe an overreaction.
I have to agree with you there. I'm not sure they're going to get that relief, but here's something else they want, and you let me know if you think they're going to get this. They want all communications and depositions between the state and the Church of Latter-day Saints, between the state and the Idaho Department of Health, between the Idaho Department of Health and that doctor who was treating her, and they want that doctor off the case. Do you think they get those?
I'm not sure that the court has jurisdiction to remove a doctor. You have to understand that, the judge is only the arbiter over the judicial proceedings. He is not the direct supervisor of clinicians in a state hospital. They have their own chain of command. They have their own, internal established hierarchy of management. You can't just go in there and say, you, doctor, you're out. I want so-and-so now to be treating this defendant. It doesn't work that way. He certainly has the power to lodge complaints, bring people in, maybe threaten people with sanctions and contempt, et cetera, if they don't follow orders. But I don't think that a judge's jurisdiction extends that far.
You know what's interesting, Philip? Last question for you on this. You saw the response there by the state saying essentially this is not stuff that should be public. This kind of thing we like to keep behind closed doors. We notice now that many of Lori's competency hearings are no longer public. None of the paperwork, nothing that goes on in court is public. They filed this publicly, her attorney. Maybe this is just some information he wants to get out into the public eye.
That's very possible. But, when he files the papers, I don't know why they're not filed under seal. Why can't he just do that so that you need a court order to unseal them and make these papers public? And why can't he, for certain proceedings, ask for closed-door, non-public hearings on this issue? I think a judge can do that in light of the fact that this involves sensitive, HIPAA-protected, and some attorney-client communications that are privileged that should not be made public. I don't have a problem with that. And yes, for him to be going around publishing motions and briefs, et cetera, without getting a court seal to make them non-public, yeah, it does give the aura of trying to make these issues go public to taint future jury pools for the Daybells.
Yep, we have to keep an eye on this whole thing. And there's a whole lot more going on with this Daybell case we're going to get to a little later. Philip, stand by, because we have stunning audio tapes of Alex Cox's ex-wife, of course.